Twilight of an Empire. By Zhongwen and Boya. Chapter 12, The Weaponization of the Judiciary. Opening. Dear listeners, in a society governed by the rule of law, the judiciary is the last line of defense. When executive power is abused, when the legislature is paralyzed, when social conflicts cannot be resolved through political negotiation, people turn to the courts, hoping to find impartial justice there. But when the judiciary itself becomes a tool of political warfare, this last line of defense begins to crumble. Today, we're going to talk about the politicization and weaponization of the American judicial system, one of the most concerning trends in contemporary American legal and political scholarship. 1. The ideal of judicial independence. Montesquieu long ago observed, in the spirit of the laws, if judicial power were combined with legislative or executive power, liberty would cease to exist. This is a core principle of the separation of powers and a fundamental axiom of modern rule of law societies. America's founders deeply understood this principle. The system of life tenure for federal judges was designed precisely to insulate the judiciary from political pressure. In theory, once appointed, a federal judge has no need to worry about re-election, votes, or political wins, and can decide cases solely on the basis of law and the Constitution. This ideal has had brilliant moments in American history. The Warren Court's 1954 Brown v. Board of Education decision, which struck down racial segregation, is a classic example. Chief Justice Earl Warren was a Republican appointed by Eisenhower, yet he delivered a landmark progressive ruling that greatly displeased the president who had named him. For decades, this story was held up as the classic model of judicial independence. But stories like this are increasingly difficult to imagine today. 2. The politicization of the Supreme Court. The root cause of the Supreme Court's politicization lies in the fact that its decisions now extend far beyond pure legal interpretation into policy areas that ought to be determined through democratic processes. Abortion rights, same-sex marriage, gun control, immigration policy, election law, these are fundamentally value-laden policy issues. With Congress deadlocked, they have all been brought to the Supreme Court, where 9 justices are asked to supply constitutional answers. But the constitutional text offers only vague, and often blank, guidance on these modern questions, leaving enormous room for interpretation. Under these circumstances, the justices' personal values and ideological leanings inevitably have a major impact on outcomes. The extreme embodiment of the court's politicization came in the 2022 Dobbs decision. The court, by a 6-3 majority, overturned Roe v. Wade, eliminating federal constitutional protection for abortion rights and returning the issue to state legislatures. The decision immediately triggered a political earthquake across America. Supporters hailed it as long overdue justice, opponents decried it as a major setback for women's rights, but regardless of one's position, nearly everyone acknowledged that this was a profoundly political ruling, driven, to a significant degree, by partisan politics rather than by legal principle. 3. Judicial weaponization, turning prosecutorial power into a political hunting tool. Another dimension of judicial politicization is the weaponization of prosecutorial power, the use of the criminal justice process to target political opponents. This phenomenon is not entirely new in American history, but it has reached troubling new heights in recent years. From 2023 to 2024, Donald Trump, then out of office, faced 4 separate criminal indictments at both the federal and state levels, on charges including attempting to overturn the 2020 election results, mishandling classified documents, election interference in Georgia, and falsifying business records in New York. This was an unprecedented situation in American history, a former president and sitting major party presidential candidate facing multiple criminal prosecutions simultaneously during an election campaign. Critics, however, point out that the timing of these cases, the choice of jurisdictions, and the political backgrounds of the prosecutors make it difficult to escape the shadow of political motivation. In particular, when the Manhattan District Attorney brought charges based on a legal theory widely regarded by legal professionals as highly tenuous, the charge of judicial weaponization became difficult to dismiss out of hand. The core issue is not whether Trump is guilty or innocent, It is that when prosecutorial power is widely perceived by the public as a political weapon, the entire judicial system's credibility begins to erode. 4. The partisanization of the federal courts. The partisanization of federal district and appellate courts is equally concerning. Every president actively uses the appointment power to place judges ideologically aligned with themselves on the federal bench. Trump appointed over 230 federal judges during his first term, setting a historic record. Biden has pursued judicial appointments with equal speed and ideological focus. As a result, the same executive order may receive diametrically opposite rulings in different federal circuits with different political leanings, a phenomenon sometimes called legal fragmentation. Even more troubling is the prevalence of forum shopping. Litigants deliberately file suit in jurisdictions where the political tilt favors their side, hoping for a favorable ruling. This fundamentally undermines the predictability and uniformity of the law. 5. Historical lessons: the cost of lost judicial independence. Throughout history, societies that have lost judicial independence have paid a severe price. The German judiciary of the Weimar Republic, when confronted with political pressure from the Nazi Party, showed weakness and accommodation, providing judicial cover for Hitler's seizure of power. The history of many Latin American countries repeatedly demonstrates that when courts become battlegrounds of political rivalry rather than temples of law, democracy hollows out rapidly. The United States has not yet reached these extremes, but the direction is cause for concern. When a society's citizens lose confidence in the fairness of its judicial system, they will turn to extra-legal means to seek justice or protect their interests, and that is the breeding ground for political violence. Conclusion. The rule of law is one of civilization's most fragile and most precious achievements. It requires all participants, political leaders, prosecutors, judges, and ordinary citizens alike, to jointly uphold its fairness and suprapartisan integrity. When the law becomes a weapon, no one is ultimately safe. Those who use the law as a weapon against their opponents today will eventually find the same weapon turned against themselves. This is not a threat, it is a logic that history has confirmed time and again. Thank you for listening.